I mean, I don't know when the court is next available, but really,
so
we just need to
Mr.
look
Fry, I'll enter a plea of not guilty. My next available is March 18. But what I will tell you is if you get a resolution, I'm available 5 days a week and we'll bring them in sooner to take that plea.
I hear that part, Your Honor. I just couldn't. Everything else is bits and pieces through coming in.
Okay, March 18
it's even hard to talk to my attorney.
Mr. Hall.
Right at the start, we're jumping into a Michigan felony docket where Randall Lambert appears ready to plead no contest to felonious assault. There's an agreement for no upfront jail, but probation risks loom large. This one moves fast. Subscribe for more dramatic courtroom breakdowns.
So I have a gentleman joining me from MDOC. Can I ask your name, please?
Kyburn Street.
All right, thank you, sir. I am going to change your screen name. Miss Underwood is your attorney, and she moves back and forth between the courts. There's two of us here. So I'm gonna let you hang out with me, and then when she gets here, we'll take your case right away, all right?
All right.
All right. All right, there you go. All right, Mr. Amadeo, I do have Randall Lambert. And I have received a copy of a advice of rights and plea agreement form. Mr. Bayonetto, are you my prosecutor this morning?
I am, Judge.
Okay, thank you. Okay, Mr. Lambert, can you hear me?
Yes, I can hear you.
All right, this is in the matter of the people of the state of Michigan versus Randall Allen Lambert, file number 26-22513FH. I have William Amadeo appearing on behalf of Mr. Lambert, and I have Alexander Bayonetto appearing on behalf of the people. I have received via email a copy of a signed advice of rights by Mr. Lambert, as well as a plea agreement that states that Mr. Lambert will plead no contest to count 2 felonious assault, which carries a maximum penalty of up to 4 years in prison with no further initial incarceration. Count 1 would be dismissed at the time of sentencing, and there are no other agreements listed in this. Mr. Amadeo, is that the plea that your client's going to enter?
That's correct, Judge, and the reason for the no contest is potential civil litigation.
All right.
I thought it was domestic
Mr.
too.
Daly, was that your client who came in? Okay. All right. So, Mr. Lambert, you want to raise your right hand for me so that I can see it? There you go. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes. Yes, sure.
You are Randall Lambert?
Yes, I'm Randall Lambert.
Okay, put your hand down. Okay, good. So you've heard the plea agreement that I read on the record that your attorney and the prosecutor agreed was correct. Is it your intention today to plead no contest to count 2 felonious assault, which carries a maximum penalty of up to 4 years in prison?
I agree.
Is that, you're going to plead no contest today? Yes?
Yes. I thought.
Okay.
Yes.
No, it's okay, Randall. It's okay. So you understand there's an agreement to no further upfront incarceration. So at sentencing, there won't be a jail sentence, but if you violate probation, there could be. Do you understand that, Mr. Lambert?
Yes, I understand that.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Amadeo?
That's correct, Judge.
Is that correct, Mr. Bayonetto?
That's correct, Your Honor. The only thing I may have missed when you initially read off the plea agreement, there is also an agreement that Mr. Lambert's going to enter a plea on a domestic violence in district court. I think that's what Mr. Lambert was referring to when he said, I think I was pleading to domestic violence as well. The file is.
So, Mr. Lambert, there's a domestic violence charge in district court. You're going to plead to that one as well?
Yeah. Do I plead at the same time, like right now, or?
No.
No,
I didn't know.
That one's still in district court. So, Mr. Amadeo, you'll have a court date on that right, Mr. Amadeo?
That's correct. And Randall, I'll go over all that with you, but this is the deal for no jail that we talked about.
Okay.
Nothing in district court's going to affect that. We just got to finish that up, but we're good to go. Everything we talked about is in play right now.
Okay.
All right, so you understand, Mr. Lambert, you're pleading to a felony up here, but you still have a district court domestic downstairs that you're gonna have to plead to, okay?
Okay.
All right,
Okay.
if a guilty plea is accepted, or a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, Mr. Lambert, do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that, Mr. Lambert?
I understand that.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah, I understand, Your Honor.
All right. Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation. You will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Lambert?
Oh, Your Honor.
All right, your attorney is advised that you're going to be entering a no contest plea. So your response to my next question will either be no contest or not guilty. So, Mr. Lambert, how do you wish to plead to the charge that on or about December 16 of 2025 in Madison Township in the county of Lenawee, that you did commit the offense under count 2, assault with a dangerous weapon, felonious assault? No contest or not guilty?
No contest.
All right. All right, and has anyone made any threats or promises to you to induce you to plead no contest to this count?
No.
You understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that, Mr. Lambert?
Yes, I understand that, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Amadeo?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Other than the plea agreement, Mr. Lambert, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Oh, okay. Say that again.
I don't know what I was supposed to say. Am I yes or no on that?
Did I
Okay,
promise
so
you anything
there's
other
an
than-
agreement for no upfront jail, Mr. Lambert. Did your
Okay.
attorney promise you about a term of probation or how much fines and costs would be?
No.
Okay, good. Is it your own choice to plead no contest?
Yes.
All right, so who's going to place factual basis upon the record?
Judge, I did hand in a police report. I don't know if that's good enough, but if not, I turn to Mr. Bayonetto. I'm kind of in my car right now, and I thought the police report would help, but if he can't,
I've got it pulled up if you want me to put it on the record, Judge. I can do
Yes,
that.
Mr. Bayonetto.
Okay. Your Honor, reading from police report number 250003063, authored by Officer St. McCloskey with the Madison Township Police Department. Your Honor, had this matter proceeded to trial, the people would have proven beyond a reasonable doubt that on or about December 16th, 2025, in Madison Township, County of Lenawee, State of Michigan, the defendant, Randall Lambert, did assault his girlfriend, Jennifer Ellis. Upon information and belief, the two parties did live together. Mr. Lambert was found at the residence. He did have bond conditions in which stated he was not to have contact with Ms. Ellis nor be at the residence at 276 Tiffany Street. Your Honor, when officers made contact with Ms. Ellis at that time, she had indicated to the officers that Mr. Lambert did hit her with a small wooden gate. While a wooden gate is not by definition a dangerous weapon, it would have been used in such a way that it could have led to physical injury of the victim. Given that, I think the elements of felonious assault are satisfied, Your Honor.
Any objection or additions, Mr. Amadeo?
No, Your Honor, we'll stipulate for factual basis purposes.
All right, so based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about December 16 of 2025 in Madison Township in the County of Lenawee, that the defendant did commit the offense of felonious assault by striking the victim in this matter with a wooden gate and choking her against the wall. And they were previously or currently in a dating arrangement, and he did not intend to commit the crime of murder or inflict great bodily harm less than murder. Has the court complied with MCR 6.302 B, C, and D? Mr. Amadeo?
Yes, you have, Your Honor.
Mr. Bayonetto?
It has, Your Honor.
All right, I accept it has, or do you have a question, Mr. Bayonetto? You said that in a questioning manner.
Sorry, it has, Your Honor.
Okay, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the no upfront jail Killebrew agreement between the prosecutor and the defense counsel, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for pre-sentence investigation. Mr. Amadeo, are you available for sentencing on April 2nd at 8:15 in the morning?
We'll make that work. Thank you, Judge.
All right, Mr. Lambert, I'm going to set this for sentencing on April 2nd at 8:15 in the morning. There is an agreement to no upfront jail. Do you wish to appear via Zoom or in person?
The judge refers Lambert for a pre-sentence investigation and locks in April 2nd for sentencing. That's critical. The probation report now becomes the roadmap for punishment. Even with no upfront jail agreed, violations or bad background findings could shift everything dramatically before sentencing day arrives.
Zoom will be fine, Your Honor.
Okay, so Mr. Moore, are you waiting to be put in a breakout room with him?
Yes, Your Honor.
All right, Mr. Lambert, I'm going to put you in a breakout room with Mr. Moore from the Michigan Department of Corrections. He's going to give you some instructions. Make sure you follow through and meet with them. When you meet with them, be truthful about your background. You do not have to make a statement about the events that occurred because you pled no contest. So they will prepare a pre-sentence report, and Mr. Amadeo will review that with you before the day of sentencing. And then we will see you back on April 2nd at 8:15 in the morning. All right,
Okay.
now go ahead and join that breakout room. And when you're done, you can just hang up. All right, Mr. Lambert?
Okay.
Thank you,
There
Judge.
you go.
Have a good day.
Thank you. Okay. Miss Adams, could we call Brian Fry, please? Evidently, they took one of his clients in custody. He's on our floor, and we can sneak him in before district court judge gets here. Maybe we can take care of it. Christopher Wade. All right, I'll get to you in just a minute, Mr. Daly. Give me just a minute. Mr. Mawad, is there a Matthew Hood here? Mr. Hood, you want to come up to the podium?
Thank you, Judge.
Welcome.
Good morning, Judge.
Good morning. All right, this is in the matter of the people of the state of Michigan versus Matthew Allen Hood Jr., file number 25-22480FC. Mr. Hood is represented by Elias Mawad, and I have Alexander Bayanetto appearing on behalf of the people. I do have a note that Allison Arnold is the prosecutor of record on this file. This is the date and time set for a pretrial conference. Mr. Mawad, how would you like to proceed today?
Your Honor, there's been a plea agreement that's been entered into whereby counts 1 and 2 would be dismissed. In exchange, my client would plead guilty to added counts 3 and 4, which is accosting and soliciting. He is HIDA eligible, but I've told Mr. Hood that is something that you will make a decision on if he's eligible at the time of sentencing.
All right, does your client wish to avail himself of that plea today?
Yes, yes. Hi, Alex.
All right,
Morning,
we
Alex.
have handed to Mr. Hood an advice of rights. So Mr. Hood, you can go through that when I read it to you, or you can read it right now and I'll go through it again, whatever you would like. So go ahead and read it.
Your Honor, does the court have an amended information on this yet? I see one
I have
in
an
the
amended
file.
information and a plea agreement form, so yes.
Okay.
Yep. I also have a letter from Darren Coast, pretrial services coordinator, that Mr. Hood is on a GPS tether. He has a 9 p.m. to 6 a.m. curfew and he has not violated.
Hi, Mr. Moore.
How we doing?
Mr. Moore, I don't know if you heard the plea.
No.
This is Mr. Hood, Matthew Allen Hood. I believe he's on my page 4, might be page 3 of yours. He's going to be pleading guilty to count 3 and count 4. Count 1 and count 2 will be dismissed.
Okay.
And if he's eligible, he might be sentenced under HIDA, but he understands that the court may choose not to do that. And there's no other terms to that agreement that I see. Correct, Mr. Bayanetto?
That's correct, Your Honor.
Yeah, that is correct, Judge.
Mr. I'm going to have you stand there for 1 minute, okay? So in the matter of the people of the state of Michigan, you can stay there, Mr. Howard, versus Claude Jalen Howard, file number 25-22458FH. I have James Daly appearing on behalf of Mr. Howard. This is a contempt pretrial, Mr. Daly. How are you going to proceed? Just hold on.
Your Honor, I
You're
think
good.
at this time, what's happened is Mr. Howard is in the process of retaining another attorney. Right now, if I was staying on the case, I don't know that I am, because of recent developments, I want him sent to a final file petition to have him examined at the forensic center. There's some serious issues there that I need to be addressed. So I think for right now, what I would like to do is have him scheduled for an evaluation at the forensic center. I'm still on the case, and that's what I intend on doing as long as I'm in the case.
Right.
But I don't know how long I'm going to be in here for.
Mr. Howard, have a seat right there. Or Mr. Hood, have a seat right there. Mr. Howard, you come up and stand next to your attorney. Okay, so Mr. Howard, your attorney is advised, so today was a contempt of court pretrial. Your attorney is advised that, has he already been sentenced on this? Let me see.
No,
Judge,
His sentencing was January 30th, right?
Judge,
Yeah,
His sentencing and another contempt was scheduled for Friday, February 13th.
okay. So he's already pled on this file, Mr. Daly?
Yes,
All right, and he is set for sentencing. So Mr. Howard, you stated that you're retaining other counsel?
Yeah, I was looking into it for the additional hearing for the second count.
The second count of what?
he's been charged again, and the court doesn't have any record of it yet.
Oh, yeah, well, yeah, okay, so you got new charges.
Yes.
All right, so Mr. Howard, do you understand that Mr. Daly has some concerns and would like to have a psychological examination done?
Yes, I do.
Okay, now he's making that motion today. Do you have, obviously that motion would have to be made on the district court file as well. Well, do you wish to proceed with his motion today, or do you want me to adjourn this for you to seek other counsel?
I would say the psychic evaluation was fine.
All right, so Mr. Prosecutor, Mr. Bayonetto, so Mr. Daly has some concerns, and obviously he hasn't gone into them on the record, but he's making a motion today for forensic examination for competency and criminal responsibility. Mr. Bayonetto, do you take any position?
No, Your Honor.
All right, so Mr. Daly, if you want to file the petition in the order today or tomorrow, that will get signed. Now, listen to me, Mr. Howard. Mr. Daly will receive the paperwork on when your court appointment, where your appointment would be with the forensic center. It will create a delay. All right. And so he will send that to you. But because you're not in jail, you have to make sure you go to the forensic center over in Pittsfield Township.
Okay.
For that appointment.
Yeah, not a problem.
Okay. All right. So Mr. Daly, if you could submit that, and Mr. Howard, I'm just going to give, are you still downriver?
Yes, I am.
Are you on Kennebec?
Yes, I am.
Okay. We got a valid address. Okay. All right. So Mr. Howard, stay in contact with Mr. Daly. If you retain counsel, have them reach out to Mr. Daly.
All right.
All right. And I'll sign that order upon presentation, Mr. Daly.
Thank you, Your Honor.
All right. Thank you both. Miss Adams, do you wish me to adjourn next Friday's hearing out?
I would say so, Judge.
All right, so I'm gonna adjourn hold on, don't go anywhere. You have a hearing like next week. I'm gonna adjourn that out to April 8th, okay? Miss Adams, would it be possible to get a notice of hearing for Mr. Howard today?
Yes, Judge.
April 8th at 8:30. So you have a seat right behind you on that bench. And then we will get you a copy of that notice, and Mr. Daly will put one in your mailbox, all right?
Thank you, Your Honor.
Thank you. All right, sorry, Mr. Mawad, Mr. Daly was here at like.
Oh, no.
I
Oh, no. Are you kidding me, Judge? I'm not like that. You know that. No problem.
I know you're, okay, so, Mr. Hood, you go back up to the podium now. We'll switch back to you. All right, there we go. All right, so I have now received a copy of the advice of rights signed by Mr. Hood, but Mr. Hood, I'm going to go through those with you again, okay? Say yes.
Yes.
Okay, you gotta speak loudly. All right, so Mr. Hood, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 3, children accosting for immoral purposes, which carries a maximum penalty of up to 4 years in prison and a $4,000 fine? This is a tier 2 offense under the Sex Offender Registration Act. Let me pull that up. Make sure I know what that is. Can't remember them all the time. So tier 2. Tier 2, you must verify your residence and personal information in person twice a year for 25 years, and you are to be listed in the public registry. Do you understand that?
Yes, Your Honor.
All right. And then is it your intention to plead to that count as well as count 4, children accosting for immoral purposes, which is also a 4-year felony and or a $4,000 fine, and also, again, a tier 2 offense under the Michigan Sex Offender Registry Act. So do you understand that it will have that requirement that you register?
Yes, Your Honor.
If you get sentenced under HIDA, that may change, but I'm not sure, okay?
Yes, Your Honor.
Okay, good. All right, so are you satisfied with, was this a guilty plea, Mr. Mawad, you said?
Yeah, yes, Judge, it would be a guilty
Okay.
plea.
Are you satisfied with Mr. Mawad as your attorney and the advice that he has given you?
Yes, Your Honor.
And neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Mawad?
Yeah, that is correct, Judge, and thank you for explaining.
Mr. Bayonetto? Oh, I'm
That's
sorry. Go
correct,
ahead,
Your
Mr. Mawad.
No, I was just going to say thank you for explaining. Matt understands that HIDA, it's not something he may get. It's going to be your consideration, and then Mr. Moore gets to give us his opinions too.
Now we shift to Matthew Hood's plea. 2 counts of accosting for immoral purposes, both Tier 2 sex offender registry offenses. The judge makes it clear, 25 years of registration, public listing, twice-year verification. That's not minor. Even HIDA eligibility isn't guaranteed here.
Okay. All right. I just forgot where I was. Is that your
sorry.
understanding as well,
Yeah.
Mr. Hood?
Yes, Your Honor.
Okay. So if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea, hold on, do you understand that, I was looking because a bunch of people popped up. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so, pull this up. So, Mr. Hood, how do you wish to plead to the charge that on or about September 16 of 2019 in the city of Adrian and the county of Lenawee that you did commit the offense listed under count 3, children accosting for immoral purposes? Guilty or not guilty?
Guilty, Your Honor.
And how do you plead to the charge listed under count 4, children accosting for immoral purposes? Guilty or not guilty?
Guilty, Your Honor.
All right. And has anyone made any threats or promises to you to get you to plead guilty to this charge?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Mawad
None, Your Honor.
and Mr. Bayonetto?
No, Your Honor.
All right. Has your attorney promised you any other particular sentence or estimate of what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Hood, on September 16 of 2019, we're in the city of Adrian in the county of Lenawee.
Yes, Your Honor.
All right, and just make sure you speak loud, okay? And at that time, I don't know, Mr. Mawad, or do you want to put the factual basis on the record?
I can. Matthew, in order for the judge to accept your plea, we have to talk about the facts of the case for counts 3 and 4, okay?
Yes,
So on September 16, 2019, you were in the city of Adrian, county of Lenawee, correct?
Yes, sir.
At that time, did you entice or solicit a child less than 16 years of age through the internet to commit an immoral act or an immoral sexual act and to submit to an act of sexual intercourse or an act of gross indecency, excuse me? You would agree with that?
Yes, sir.
And you would agree that that person was a minor, less than 16 years of age?
Yes, sir.
And that happened twice on that date for counts 3 and 4, correct?
Yes, sir.
Same thing. You accosted and solicited a minor who was under the age of 16 to carry out some act of some sexual act or indecency or anything concerning a minor with the sexual act, correct?
Yes, sir.
All right.
Are you satisfied, Mr. Bayonetto?
Yes, Your Honor.
All right, has court complied with MCR 6.302 B, C, and D? Mr. Mawad? Thank you.
Yes, Your Honor.
Mr. Bayonetto?
It has, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for pre-sentence investigation. Mr. Mawad, are you available on April 2nd at 8:15?
That'll be fine, Judge. Sure.
All right. So that'll be in person, but obviously, Mr. Mawad, you can appear via Zoom. Miss Adams, could I get a notice of hearing from Mr. Hood?
Yes, Judge.
All right, so Mr. Hood, I'm gonna have, in a minute, I'm gonna have you have a seat right behind you on the bench. We're gonna give you a copy of a notice of hearing. Then you're gonna go across the hall to the probation department and check in. They'll probably give you a packet and some instructions. At some point, they'll set up a time for you to meet with them. Make sure you appear for that meeting. Be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. Mr. Mawad will review that with you before the day of sentencing. And then we will be back here in person on that day, okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right, have a seat right behind you. We'll get that notice and then you can go across the hall.
Thanks, Judge.
Thank you. Is that all you had, Mr. Mawad?
That's all today, but I'll be back to bug you later.
Oh, no problem. Thank you.
Okay. Bye-bye. Bye, Mr. Moore. See ya.
See you later.
Mr. Raines. Mr. Raines, let me see.
Good morning, Judge.
Good morning. Do you have Mr. Jordan with you?
I do, Your Honor. He's present in my office.
Okay. Let me see who this other person is. They stuck you right in the middle of my morning docket. I apologize.
Okay.
All right.
Sorry.
I have somebody on a Google Pixel device I just admitted. What is your name, please?
David Beyer,
Spell your last name.
Beyer.
David
All right.
Bayer appears briefly after waiving arraignment, calling in from rehab. It's procedural but important. He's formally entered into the system and must stay in contact with counsel. Miss a step, miss a hearing, and things escalate fast in felony court.
All right. And who's your attorney?
Goldstein.
All right.
Your Honor, I think
tried.
Mr. Goldstein waived this arraignment.
Yep, I just saw that. All right, so Mr. Beyer, I'm gonna call the case, but you signed a waiver with your attorney, so you didn't need to come today. So in the matter of the people of the state of Michigan versus David Michael Byer, file number 26-22537FH. David Goldstein represents the defendant. I have Alexander Bayonetto appearing on behalf of the people. So you did waive arraignment, so you'll have another court date set. Just stay in contact with Mr. Goldstein, and then we will mail a notice of hearing to you, okay?
Okay, I'm in the rehab, Ms. St. Zone, and I've been trying to contact Mr. Goldstein, and I've not received a call back from you yet, but I don't have my telephone here at all times, so that could be a reason. So
Okay.
I will
All
try to
right.
call him today and let him know, and then I will talk to you, and you have a very blessed
Well,
day.
he already knows because he had you sign the paperwork. You already signed the paperwork to waive today. So, yep. All right. Thank you, Mr. Byer.
Okay, have a
Good
blessed
luck.
day. All right, thank you.
You
Bye-bye.
too. Bye. Okay, so let me grab your file in the matter of, where'd you go? Mr. Fry, you have a client that was taken into custody today. Did you already talk to him?
I have not, but you need to. I expected that to happen. Do you need to talk to him? I'll talk to him. Answer that.
All right, you want him brought down?
Yeah.
Okay, this is in the matter of Lisa Fisher versus Andrew Lee Jordan, file number 2012. 2012-37840PH. I have Lowry Rains appearing on behalf of Mr. Jordan. And let me see. All right, so, oh, okay, I see. So back, let me go back. Today's a pretrial on a contempt of court. And let me go back. Judge Pickard. Okay, so on April 5 of 2012, Mr. Rains, Judge Pickard entered a permanent personal protection order that was dated April 5 of 2012 at 10:20 a.m. There is an allegation that the personal protection order was violated on or about November 3rd of 25, and that he appeared at the workplace of Lisa Fisher at some bar in Onstead. Lisa was not working, was eating dinner. He walked in and made eye contact with her and remained on property. So, so Mr. Rains, not the worst PPO violation I've had today, but how would you like to proceed, Mr. Rains?
Your Honor, this is a pretrial conference. My understanding is that my client had been arrested. He spent the night in jail. He was arraigned on this on, I believe, November 4th, and a not guilty plea was entered at that time, and this matter was set over to today. My hope was that perhaps, and if Mr. Bayonetta, who's handling this, is that in light of the fact that there's been nearly 14 years that have now been in place with this personal protection order without, I believe, even one allegation of a violation. And given what, as Your Honor has described this, perhaps one of the less, let's just say, egregious alleged violations that Mr. Bayonetta at this point in time might be willing to set this matter aside or withdraw the violation complaint. But I haven't had that discussion with Mr. Bayonetta yet.
All right, so Mr. Bayonetta and Mr. Rains, this is a lifetime PPO, and this violation, as Mr. Rains said, is not the most egregious. And Mr. Bayonetta, I would be comfortable with a strict warning and a reminder of the respondent in this matter. Let me see here. Hold on one second.
Is she on Zoom, Your Honor? Because I don't believe it would have been our office that filed it. It would be hers. I think we would only get involved if this is set for a hearing.
Okay, but Mr. Bayonetta, Mr. Bayonetta, I'm going to send you both a chat. Okay. and I could be wrong on this. Mr. Gianetto, oh, my audio just turned on. I don't know how that happened. I hit the wrong button. Okay. There we go. Freaked me out. And so Mr. Bandetto and Mr. Rains, I just kind of sent you as a chat. I'm not quite sure on the case law on that, but so in light of all of this, Mr. Bayonetto, I do agree that a police report was filed by the police. So this was authorized by the police department. I would be comfortable. He went in, he saw her, he had dinner, but I would be very comfortable warning Mr. Rains at this point to advise, or if I could see his client, I'm going to dismiss this violation of the PPO, but sir, don't go there anymore. And if you ever do see her, just leave quickly. All right?
Yes, Your Honor. Yes, Your Honor.
All right. Mr. Rains, I will dismiss this. Thank you.
Very good. Thank you, Your Honor. Will I need to prepare an order, or will Your Honor be doing that?
We do that. Thank you.
Thank you, Judge.
Thank you, Judge.
Thank you,
Thank
Mr. Bayonetto.
Thank you, Mr. Randall.
All right. All right, Mr. Fry, you have Mr. Let's see, Mr. Wade. Why aren't you supposed to stand up there with your attorney? This is in the matter of the people of the state of Michigan versus Christopher James Wade, file number 25-22446 FH. Let me call the jail real quick on your other one. Is that all right?
Sure.
Good morning, Your Honor.
Good morning. I am ready for Taylor Hafner Kubiak.
Yes, ma'am, you'll get it.
All right, thank you. Bye.
Of course, bye-bye.
So nice. All right. So this is the date and time set for a pretrial conference this morning. I have Brian Fry appearing on behalf of Mr. Wade and Alexander Bayonetto appearing on behalf of the people. So, Mr. Fry, how do you wish to proceed with Mr. Wade today?
Your Honor, if the court would be willing to grant a short adjournment, as there's been some recent discussions. If not, we'd ask for a trial date. But there have been some recent resolution discussions we're working through. So we should have a answer if we're gonna be able to work it out here in the next couple of weeks.
March 4?
That's fine.
Or I could go to March 18. That would be better.
Yeah, that works too.
All right. So I'm going to set this. Miss Adams, is he going to jail or is he just for some reason in custody right this moment?
So, Your Honor, last time we were here in circuit court, he was here, but he had a district court hearing, I think, the next day that he failed to appear for. So that's what the warrant is.
Miss Adams, could I get a notice of hearing from Mr. Wade? He can put it in his coat pocket in case he gets dismissed, gets out of jail from district court, because you're not being held on my case, okay? So I'll set a pretrial for March 18 at 8:30 in the morning. We'll do the notice because I would like to get Mr. Wade a copy. So, all right, you're all set, Mr. Wade, okay? If you get out of jail, you make sure you stay in contact with Mr. Fry, okay? Say it louder.
Yes, ma'am.
Okay, thank you. Have a seat right there. Can you have a seat right there? And Miss Adams, if you want to bring him a notice. Okay, that's fine.
Here's a probation violation hearing over unpaid restitution, nearly $19,000 owed. The judge immediately advises the defendant of potential jail exposure and appoints counsel. That's significant. Even financial violations can land someone behind bars if the court finds willful noncompliance.
Brandon Davis. In the matter of the people of the state of Michigan, oh, you just showed up. Okay. All right, Brandon, okay. Brandon Davis, if you'd like to unmute your device and start your audio.
Hi, can you
All
hear me?
right, you are, all right, you're Brandon Davis?
Yes.
Okay, so Mr. Davis, we are here in a request and summons for probation violation 22-21006, 23-21398FH. So, Mr. Davis, we have two violations simply alleging you failed to pay court costs and restitution. You owe $18,960.77. You've only paid $1,028 since this probation started. You've been on probation for a little while. So, Mr. Davis, you do have a right to have an attorney represent you on these probation violations, or you can retain counsel. Do you wish to have an attorney appointed to represent you?
I do not.
You do not?
Do I guess do I need one? I can.
Well, you potentially are facing jail, so it just depends on if you're comfortable proceeding without an attorney or you would like an attorney.
Is there a option for a court appointed attorney?
Yes.
Okay.
Would you like a court appointed attorney?
I guess so. Please.
Okay, so what I'm gonna do is enter a plea of not guilty on your behalf. I'm gonna pop you in the waiting room.
Okay.
I'm going to, when I get Miss Underwood, bring you back in so you can speak with her. It might be a little while because we've got two courts running and she's running back and forth, okay?
Okay, I appreciate it. Thank you, Your Honor.
All right, thank you. In the matter of the people of the state of Michigan versus Jeremiah Beagle, I have John Glazier appearing on behalf of Mr. Beagle, and I have Alexander Bayonetto appearing on behalf of the people. Says date and time set for a pretrial in this matter. Mr. Glazier, I do not have Mr. Beagle. Do you have Mr. Beagle?
I do not, Your Honor. He had an appointment to see me this week, and he showed up, but I was gone. I couldn't make it. I was ill. So I know he's not purposely dodging this thing. But whatever the court wants to do, I would ask to adjourn it. There's an issue. I don't think he's gone up to get his we had a psych evaluation requested, and I don't think he's done that yet.
So the issue was he failed to go.
Yeah.
And I told him if it was rescheduled and he failed to appear, I would take him into custody where I knew he would appear.
Okay.
Let me see here. Did you, I believe your office, I don't remember what happened the last time we were here. I thought the last time we were here, you were gonna reschedule it or something.
Your Honor, the last time we were here, the defendant couldn't get connected to his audio, so we didn't really get anything substantive done, except the court had ordered him to appear in person, so we could address this issue.
All right, Mr. Glazier, I'm gonna adjourn this out 1 week.
All right.
If he doesn't appear at that time, I will issue a bench warrant. So I'll set this for February 18 at 8:30 in the morning, and you can do the stip in order to adjourn. And hopefully your office, your detective will be able to get a hold of him, all right?
All right, thank you, Your Honor.
Thank you. All right, Mr. Murphy, I'm looking. James Hall, I got him, Mr. Murphy.
Could I have a breakout with him, please?
Yep, I've got Brian Fry's client. I just don't have Brian Fry. I don't know. James Hall, can you unmute your device and start your audio, please?
Yeah, I'm here. Can you hear me?
I can hear you. All right, this is in the matter of
Can you see me?
no, I cannot see you. I'll send.
I'm sorry. I'm trying to figure this out here.
Okay, so in the matter of the people of the state of Michigan versus James, stop talking for a minute. James Albert Hall. We have multiple files. We have file number 25-22427FH, 25-22428FH. And Matt Murphy appearing on behalf of Mr. Hall. So Mr. Hall, I'm going to open up a breakout room for you and your attorney. So you're going to get an invitation on your screen to join a breakout room. Go ahead and join that breakout room. When you're done talking to Mr. Murphy, if you can't find your way back, I will bring you back, all right?
I couldn't hear you. Sorry.
Join the breakout room.
Can you hear me,
Mr. Hall, you should have got an invitation to join a breakout room. Join that breakout room. Mr. Hall, can you hear me?
Yes, ma'am. But I'm getting help right now to join. This man's here to help me. She said to join the breakout room.
Oh, there he goes. Okay. All right. I have a young man from the Lenawee County Jail. Are you Mr. Hafner Kubiak?
Yes, Your Honor.
Okay. So, in the matter of the people of the state of Michigan versus Taylor James Hafner Kubiak, file number 26-22516AX. That is the extradition file. And then we have file number 26-22539FH, which is the new felony file, which is set for arraignment today. I have Brian Fry appearing on behalf of Mr. Hafner Kubiak, and I have Alexander Bayonetto appearing on behalf of the people. So, Mr. Fry, how would you like to proceed today?
Yes, Your Honor, we would ask the court to enter a not guilty plea. We would acknowledge receipt of the information in the prosecutor's witness list. In this case, Your Honor, we've had some discussions about resolution, and I think we're extremely close. I think we can get this resolved. We just need like a week. I mean, I don't know when the court is next available, but really,
so
we just need
Mr. Fry, I'll enter a plea of not guilty. My next available is March 18. But what I will tell you is if you get a resolution, I'm available 5 days a week, and we'll bring them in sooner to take that plea, because I'm sure Mr. Hafner Kubiak would like to get this taken care of and go on his way. So I will set this in the extradition over to March 18 at 8:30 in the morning. Mr. Hafner Kubiak, if there is a resolution that has been reached, Mr. Fry will schedule you in sooner, okay?
Okay.
Okay, all right. Anything else, Mr. Fry?
nothing further, Your Honor. Yep, nothing further. Thank you.
Okay, all right. Thank you both. Thank you, Mr. Hafner Kubiak.
Thank you, Your Honor.
Now we're into extradition and new felony charges. A not guilty plea is entered, but resolution discussions are already happening. The judge makes it clear if a deal is reached, she'll take the plea immediately. That flexibility can mean everything for defendants sitting in custody.
Okay. So, you're right there, Mr. Street. It shouldn't be too much longer, okay?
It's all right. Just doing your job.
All right, all right, Owen, what is your name?
Michael Guzman,
Spell your last name?
Guzman.
And who's your attorney?
It's a pro bono lawyer. I think of his name right now.
Sam Malaro, you mean a public defender?
Yes.
They're not pro bono, we pay them. All right, got it, okay. So Mr. Malaro's still down the hall or somewhere, so he'll be back.
Okay.
All right, so mark that you're in person. All right, so Mr. Glazier, I think we had one more. We had Huston Erwin. In the matter of people of the state of Michigan versus Houston Huston Eric Owen, file number 25-22420FH. Mr. Owen is currently incarcerated in the Marquette Branch Prison. And we mailed a notice and we sent an order for fingerprints. And Miss Adams, is this something the prosecutor did a writ, or was it one of the email ones?
Let me check. Judge, it looks like on January 14th, I emailed to the prosecutor.
So the prosecutor's office would have done a writ?
Judge, sometimes it depends on the facility. I think sometimes they just do it off the order. Sometimes we have to do a writ. So I don't know.
All right, so I think Mr. Bainetto, in light of the fact that MDOC has neither fingerprinted him or produced him, could we do an official writ for the next one? And I'm going to set it out.
He's in Macomb now.
Oh, he's in Macomb now, by the way.
Okay.
Thank you. All right, so we'll do a writ, and then can we writ him out to be in person?
Yes, Your Honor.
That way
I'll
we
make
can
sure.
fingerprint them. So I'm going to set it out to March 18 at 8:30 in person. So if you can have them physically brought here, we could do the fingerprints on them as well.
Yes, Your Honor. You said March 18th?
Yes, at 8:30. All right, Mr. Glazier, I don't think I have anything else with you.
So, Crane Rosenkrantz.
Craig Rosenkrantz,
Yeah.
he is not today. He's my file, but he is not scheduled for today. I think he was here last week.
Okay. I have him on my schedule for some reason.
All right, I think that's all I have with you, Mr. Glazier. Thank you.
All right. Thank you.
All right, Mr. Murphy. I I have Mr. Hall back. So, Mr. Murphy, let me grab Mr. Hall's files again. How do you wish to proceed today on Mr. Hall, Mr. Murphy?
Your Honor, from my understanding with communications from the prosecutor's office, Mr. Hall, his offer would be for him to plead to an OWI second on, would that be 2522427 FH?
Yes.
And then an attempted MDOP of police or fire property, and 1 count of resisting opposing officer, and file 2522428 FH, dismissal of the remainder in that file. An agreement for Mr. Hall to have suspended jail, upfront jail, no upfront jail. I don't think you would guideline to jail, but if there was, it would be suspended. And for probation, whatever length of probation the court would order. Mr. Hall is currently in a rehabilitation facility. He was in Bear River. And then he went to, I'm trying to figure out, I think it's New Haven or Haven, if I'm not mistaken, the Haven and Battle Creek, scheduled for, I believe, another, it's got, I think, another 12 months or so to go. There's been some issues with trying to communicate with him. His Wi-Fi is messing up right now, so it's just sporadic right now. He's had some, we've had appointments scheduled and he hasn't been able to connect to complete those. So I'm asking if the court would be okay with one more adjournment and if Mr. Baynetto would object. Again, I relayed to Mr. Hall, we obviously have to communicate. So these issues, whatever is causing communication issues, has to be cured because we need to discuss this. The case can't continue on indefinitely. He's doing well in his recovery. The only thing is he's sick right now, but that's the only thing he was trying to express. But he's doing well. Well, I'd let Mr. Baynetto know that as well. I don't think there's any issue ultimately in resolving this case. It's just trying to explain to him the details of what we're talking about and what can be entailed, what he should expect. He was asking for that adjournment. So if we could, Your Honor, that's what he's asking for.
Okay, on file number 25-22428 FH, it was plead guilty to count 1 and count 2.
It's not, Your Honor. It as of now, the offer is plea to counts 3 and 4. So 1, resisting and obstructing the assault and battery as charged, and then Mr. Murphy did have the OWI second with an agreement to no upfront jail. That part was correct, and then restitution to be determined as it relates to the destruction of the police and fire property.
Okay, I was just trying to get that straight. All right, and then there would have to be an amended information on file number 25-2247 because I only have operating while intoxicated and a third offense notice.
Yes, Your Honor. If the defendant does avail himself of that plea, I'll make sure the court has an amended.
All right, so Mr. Hall, your attorney is asking for an adjournment.
Well, on my
so that
end,
he can...
it's hard for me to.
So I'll just hold on. The judge just explained something to you right now. So just let her speak.
I'm working with.
Oh, well, I guess.
Can you hear me, Mr. Hall? All right. All right. Well, anyway, Mr. Murphy, I'm going to set this out to March 18 at 8:30 in the morning. And we'll
my office do a stipulation order for that, Your Honor. Is it okay that we sign your name with permission, Mr. Baynetto?
Yes, thank you.
And could you email me the offer, please, just so I can make sure I got it.
Sending it over right now.
I'm going to send a chat to Mr. Hall, pre-trial March 18 at 8:30.
I can hear that part, Your Honor. I just couldn't. Everything else is bits and pieces through coming in there.
Okay, March 18
it's even hard to talk to my attorney.
Mr. Hall,
Yes.
March 18 at 8:30 in the morning is your next pre-trial, all right?
It's my next pre-trial. Very good. Thank you.
Okay. All right. Thank you. Bye.
Thank you.
Thank you, Mr. Hall. I'll talk to you soon.
All right.
Thank you, Your Honor. That was all that I had scheduled, I believe. So I was going to log off.
All right. Is Mr. Malaro here today?
He is. I believe he's probably in Judge Olstaver's right now. I think he had a lot in Judge Olstaver's.
I don't know. His client, he had one in front of me and his client's here.
I'll make sure he knows that that's still pending and if he wants me to cover anything, but I got stuff in Judge Olstaver's as well.
I only have 2. All right.
From felonious assault pleas to Tier 2 registry admissions, probation violations, PPO dismissals, and extradition hearings, this docket shows how quickly outcomes shift in court. Some get warnings, others face life-altering consequences. That's real courtroom justice. Like, comment, and subscribe for more shocking courtroom stories.